Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Hello, everybody. How are you? I am back. I'm live. Let's see what's been going on. I have a cat in here that I didn't know was in here. Okay. She's saying hi to everybody if you heard her meow. Boy. Well, let's see. I left Indiana a week ago. So last Sunday was the Flora 4 Memorial Walk, and I think I left Flora around 6:30ish and actually got on the road about 7. I dropped one person off in Delphi, and then I dropped Randy off at home, and he gave me a new way to take home. My original plan, because I was leaving so late, was to drive like halfway, stop, spend the night somewhere, and then get up the next morning and finish coming home because we were supposed to get snow. Well, that didn't happen because Randy gave me a different route to take home, and it only took 6 hours instead of my normal 8, and that was with stops. So I drove straight through. I got home at about 12:18 in the morning, brought all my stuff in and talked to my husband for a little bit, and then shortly thereafter we went to sleep because I was exhausted and he wasn't feeling good and my son wasn't feeling good, so I came home to sick people, unfortunately. But my days have consisted of sleeping and doing research and sleeping some more. So I appreciate everybody understanding that I needed a break. I've got to spend some time with my son and with my husband in this week. And so that was much needed time with them and just to recuperate from everything that we went through. I don't know if any of you follow Aspen, but last night he was trying to get home and he had a hell of a time getting home because they kept having mechanical issues with his plane. I was up until about 2:30 a.m. and he had finally messaged me and said he got home safely. So Aspen, I'm so glad you made it home finally. You were there a lot longer than I was, and you're turning around and going back. So come to find out, I get home early Monday morning, and we had rain Monday. We woke up with a very, very little bit of snow, not much at all, on Tuesday. And Indiana actually got hit with more snow than Wisconsin did. As I was talking to Andrea on Tuesday, we don't have any snow. So I think it all went towards Indiana and that way because there's just absolutely none here. Let's see. Get out of my kitchen. Have to go to work, but going to listen on replay while I'm there. Awesome. Thanks for listening to the replay. I know everybody can't be here with me all at once. I'm doing this. I was planning on doing this an hour earlier than usual. One of the things that has happened to me in the past month is the days have run together. I don't know what day it is, and times, and trying to change times between the two time zones still has me confused. I'll get it together, I promise. Linda says, hey, Marv, did you make it home? Yep, I sure did. And let's see. Andrea's been answering questions. Hey, Jill, how you doing? Miss Lori, nice to see you. Cyber Warrior, thanks for joining us. Who else do I have? Stephanie, hope you're feeling better. Yeah, I've got a cold again because of this weird weather here, but otherwise I'm doing good. I needed a break. Yeah, absolutely. Even though I took a break from doing lives, I could tell you that I've been reading things. I've been watching different things about the Delphi case. I can tell you that I have been very frustrated in humanity. I've been very angry with humanity. I know that my community here does not support the things that are happening out there right now. And I just want to thank you all for that. There are good people in this world. There are angels in heaven watching over us. But there's also, I believe, some angels walking around here with us also. And for people to be doing what they're doing to the families right now is disgusting. It's unexcusable. And it makes me sick. And that includes what they're saying and the fact that they're sharing the pictures. So I see our troll is back. Let me get to him here. I guess it's going to be one of those nights where I've got to ban many Brandon Rhodes logins. So, I don't know why they don't leave the families alone. It's ridiculous. The family bashing that's going on, the things that are being said about Kelsey are absolutely incorrect and disgusting. And the other day I went off on a complete rant here at the house while I was by myself and just lost it. They're doing the same thing for the Idaho 4 families. Yeah. You know, there's so many keyboard warriors out there right now. I challenge each and every single one of you. Go say these things to a direct family member. If you're going to go out there and say this crap, at least have the respect to say it to their face. Because I want to be there when they knock your block off. And that's exactly what you deserve. It's exactly what you deserve. If you can't say it to their face, then don't say it at all. That's my position on it. So tonight we're going to start my little post-conviction series. And the first thing that we're going to talk about is the law in Indiana, third-party defenses, and hearsay. I did a lot of research on this, and I tried to get as much information for you guys as I could, because there's two things that I hear people bitching about the most, and that is that the Odinist theory was not allowed in and should have been, that the sketches weren't shown, and then I've heard other things that we'll go into later. But tonight we're going to talk about the third-party defense and the hearsay for the sketches. And then tomorrow night, we're going to look at the Franks motion that the defense gave us. All four of them, in fact. It's probably going to take 2 nights to do that, honestly. There's so much in the first one and then a little bit in the second, third, and fourth. So we're going to look at whether the information in the Franks was speculation or evidence. Because it makes a big, big difference as to whether that information is just speculative or if there's actual evidence and what is considered evidence and if it should have been allowed in. The sentencing is December 20th. So we just have under a month for that. And so let me share my screen here. Okay. So if you're not familiar with how I get some of my information, you're going to learn tomorrow. I use Bing, and I ask it questions, and I get answers. And then it gives me other sites that I can look at to show what's real. So, the first thing we're going to talk about is the third-party defense. In a criminal trial for murder, a third-party defense strategy involves arguing that someone else committed the crime. So how does it usually work? Well, you present an alternate suspect. In this case, the defense presented the Odinist theory and gave the names of Brad Holder, Patrick Westfall, and Elvis Fields. So, when you're presenting an alternative suspect, you have to have evidence of another perpetrator. The defense presents evidence suggesting that another individual had the motive, opportunity, and means to commit the murder. The defense may provide an alibi for the defendant, showing they were elsewhere when the crime occurred. Well, we know that in the trial, the defense was trying to state that Richard Allen was at home by the time the girls were murdered, but they were never able to prove that because Richard Allen himself kept changing the time. And the defense has stated that, they presented evidence suggesting that another individual had the motive, opportunity, and means. But did they really? Because The one thing that the judge kept saying is that she would review the Odinist theory again if they could provide evidence. And just having Pearl Nutter come in and testify is not providing evidence. I can tell you that right now. Now, one of the things that they did try to do during the trial is undermine the prosecution's case. They attacked the credibility of witnesses. They challenged the credibility of the prosecution's witnesses, pointing out inconsistencies or biases in their testimony. And the defense absolutely did do that in this trial. However, the jury did not believe what they were being told by the defense. Expert testimony. Forensic experts. The defense may call forensic experts to testify that the evidence does not conclusively point to the defendant. They brought in psychologist, psychiatrist. I have to see if they brought in a gun expert. I believe they did. Somewhat. Oh, yes. That's right. Their gun expert never ever looked at the actual gun or bullets. Everything that they said, they saw from pictures. That's right. So they never actually once held the gun in their hand. They never actually test fired their own bullets to compare under a microscope like the prosecution's witness. They never had a third individual verify the first individual's results like the prosecution's witness did. They just looked at pictures and decided it didn't match. That was their evidence. Psychological experts. Experts might testify about the defendant's mental state or suggest that someone else had a psychological profile consistent with the crime. We did hear from them. We heard that the defendant had all these episodes when they were given Haldol or whatever it's called. And that is the time that Richard Allen was confessing. But then they had another rebuttal witness come on saying that no, not all of the confessions were given when he was considered to be in psychosis. We'll look at all that later too. Character evidence. The defense might present evidence of the defendant's good character to suggest they are not capable of committing such a crime. This trial, the defense did not present any other witnesses other than the 4 questions to his daughter and to his sister. And that was basically stating that he did not essay them. They would not lie for him. But nothing about his character. Conversely, the defense might present evidence of the alternative suspect's bad character or criminal history. Well, they weren't allowed to bring it in, so they couldn't do that. Legal arguments. Insufficient evidence. The defense argues that the prosecution has not met its burden of proof beyond a reasonable doubt. Defense never argued that. Mistaken identity. The defense may argue that the defendant was mistakenly identified as the perpetrator. They tried to do that in the trial by questioning the prosecution's witnesses and what they saw and who they saw. So, in the context of a criminal trial, presenting evidence of opportunity involves demonstrating that another person had the chance to commit the crime. This means showing that the alternative suspect was in the right place at the right time to have committed the act. The defense had no proof that Brad Holder, Patrick Westfall, and Elvis Fields were on the bridge that day or at the crime scene. There was no witness testimony stating that any of those individuals were seen in the area. They were not near the crime scene or the bridge around the time the crime was committed. There was no surveillance footage, trail cams, videos showing that their vehicles were in the area. So, another thing is surveillance footage, video recording placing the alternate suspect at or near the location of the crime during the relevant time frame. Time evidence, logs and records, time-stamped records such as work logs, electronic swipe records, or other documentation indicating the alternative suspect's whereabouts. The defense could not provide that information, and that is why, one of the reasons why Judge Gull denied them bringing this theory, this third party, into the trial. Alibi breakdown. Evidence that challenges the alibi of the alternative suspect, showing gaps or inconsistencies. Now, this was done a little bit during the trial, especially with Brad Weber. The defense kept talking about this interview or affidavit or something stating that Brad Weber said that he was checking ATMs and did not go straight home. But that document was never provided in court by the defense. Not once. Of course, for physical evidence, there was no evidence linking the alternative suspect to the crime scene, such as fingerprint, hair, or DNA. There were no objects belonging to the alternative suspect found at the crime scene, which they would not have had a legitimate reason to leave there. There was no evidence that an alternative suspect had previously expressed a desire or intent to harm the victim. Now, one of the individuals did state that what happens if I spit on the girls? We'll get into that. Suspicious behavior. Actions by the alternative suspect that seem inconsistent or suspicious, like attempts to create a false alibi or destroy evidence. I think there was some definite suspicion because things were said by an individual, but there was nothing like them trying to create false alibis or destroy evidence, because we had Brad Holder's time card of when he punched in, or no, I'm sorry. We had Brad Weber's time card of when he punched in, when he punched out. Access to weapons. Everybody there has weapons. So, evidence that the alternative suspect had access to the weapon or tools used in the crime, showing that the alternative suspect had the necessary skills or knowledge to commit the crime. Well, all of them had that. For example, if the defense wants to argue that another person, not the defendant, committed the murder, they might present evidence that this alternative suspect was seen near the crime scene, location evidence, had made threats against the victim, behavioral evidence, and had no solid alibi for the time of the crime, time evidence. This strategy aims to create reasonable doubt by suggesting that someone else had both the opportunity and perhaps the motive to commit the crime, thus weakening the prosecution's case against the defendant. Sorry about that. In a criminal trial, when the defense presents evidence of means, they are demonstrating that another person had the capability to commit the murder or the crime. This involves showing that the alternative suspect had the tools, skills, and resources necessary to carry out the act. Here are some examples of what kind of evidence might be presented to establish means. Access to weapon or tools. Ownership or possession, showing that the alternative suspect owned or had access to the weapon or tools used in the crime. For instance, if the murder weapon was a specific type of gun, the defense might present evidence that the alternative suspect owned a similar firearm. That was presented, that Brad Weber's gun could not be excluded. Purchase records, evidence of the alternative suspect purchasing items that could be used to commit the crime, such as weapons, poisons, or tools. Special skills, demonstrating that the alternative suspect possessed the skills or knowledge required to commit the crime. For example, if the crime involved hacking into a computer system, evidence might show that the alternative suspect had expertise in cybersecurity. Records or testimonies proving that the alternative suspect received training related to the crime, such as combat training, lockpicking skills, or chemical handling. Physical capabilities, strengths, or dexterity. Evidence that the alternative suspect had the physical strength or dexterity required to carry out the crime. This could include fitness records, medical assessments, or eyewitness testimonies. Health records, documentation showing that the alternative suspect was in good health and capable of performing the actions involved in the crime. Sorry about that. Financial resources, funds demonstrating that the alternative suspect had the financial means to support the crime. This could include evidence of purchasing expensive equipment or funding activities related to the crime. Bank statements, financial records showing large transactions or unexplained expenditures around the time of the crime. Some of these don't fit with our crime, but I'm still telling them to you because I'm not going to give you just partial information. Anything that could relate to a third-party defense, I'm going to give you. Access to crime scene. Keys or security codes, well, we didn't have that. Or other means of accessing the location where the crime occurred. Employment records, proof that the alternative suspect worked at or frequently visited the crime scene, giving them access. For example, in a murder case, if the defense argues that another person is the true perpetrator, they might present evidence that this person had access to the murder weapon. They have been trained in its use and had the physical capability to carry out the crime. A statement like, "What if I spit on the victim?" from an individual with a low IQ might raise questions, but it wouldn't be enough on its own to establish a third-party defense in a murder trial. For a third-party defense to be effective, the defense would need to present comprehensive evidence that another person had the opportunity, means, and motive to commit the crime. What's needed? Key elements. Showing evidence that the alternative suspect was at or near the crime scene at the relevant time. Means. Proof that the alternative suspect had the tools, skills, or physical capability to commit the crime. Motive. Demonstrating that the alternative suspect had a reason to commit the crime, such as personal animosity, financial gain, or other motivations. Additional considerations. Credibility of the statement. The context and credibility of the statement made by the individual would be scrutinized. The defense would need to show that the statement is relevant and reliable. Supporting evidence. The defense would need to present additional evidence that supports the theory that the alternative suspect committed the crime. This could include witness testimonies, forensic evidence, or inconsistencies in the prosecution's case. In summary, while the statement might be a piece of the puzzle, it would not be sufficient on its own. The defense would need to build a robust case that includes evidence of opportunity, means, and motive to effectively argue a third-party defense. The principles of presenting a third-party defense in a criminal trial include the need to show opportunity, means, and motive. Apply in Indiana as well. Indiana law allows for the use of a third-party defense, and the defense must present evidence to support the claim that someone else committed the crime. So it asked me, would you like more information on how Indiana courts handled third-party defenses, or perhaps some examples of cases where this strategy was used? And I said, yes, I would. So in Indiana, third-party defenses are handled under the Indiana Rules of Trial Procedure, specifically Rule 14. This rule allows the defendant to bring in a third party who may be liable for all of or part of the plaintiff's claim against them. The third party defendant can then assert defenses, counterclaims, and cross claims against the original defendant and the plaintiff. One notable case involving a third-party defense in Indiana is the Delphi murder case involving Richard Allen. This case is particularly significant because it involved multiple murder charges, and the defense attempted to use a third-party theory to shift the blame away from Allen. was charged with the murders of Abby Williams and Libby German in 2017. Defense strategy. Allen's defense team proposed an alternative theory that a group of individuals adhering to Odinism, a pagan Nordic religion, were responsible for the murders. How the strategy was used. Presenting alternative theories. The defense outlined their theory that a group of Odinists was responsible for the murders. The defense filed a motion to include the third-party theory in the trial, arguing that these individuals had the motive and opportunity to commit the crime. Special Judge Fran Gull ruled that the defense could not present the third-party theory in court. She stated that the defense had not produced admissible evidence linking the Odinist to the crime, and that the theory was based on speculation and hearsay. Now, I want to read that to you all again, because this is very important. Special Judge Fran Gull ruled that the defense could not present the third-party theory in court. She stated that the defense had not produced admissible evidence linking the Odinist to the crime, and that the theory was based on speculation and hearsay. Now, in a Saturday session, the defense once again brought up the Odinist theory, the third-party defense, and wanted to bring this in. Judge Gull said to them for the final time, she said, "I'm only going to say this one more time. You have not provided a nexus to bring in the third-party defense." What does she mean by a nexus? Admissible evidence linking the Odinist to the crime. The defense had the opportunity to do this many times, but they didn't. They had the opportunity in July and August at the hearing, and the only evidence that they presented was Pearl Nutter. That was it. If they had more evidence linking the Odinist to the crime, why didn't they present it? Anybody? Anybody have an answer to that question? Evidence presented. Speculative evidence. The defense attempted to present evidence suggesting that the Odinist had a motive and opportunity to commit the murders. The prosecution argued that the defense's evidence was speculative and not based on concrete, admissible evidence. Ultimately, Judge Gull ruled that the defense could not present the third-party theory during the trial, as it did not meet the standards of admissible evidence. In the Delphi Murders case, the defense's Odinist theory was considered speculative and not based on concrete, admissible evidence for several reasons. Lack of direct evidence. The defense did not present any direct evidence linking Odinist to the crime scene. There were no Odinist artifacts, symbols, or materials found at the crime scene that could conclusively tie the murders to Odinist rituals. Hearsay and speculation. Much of the evidence presented by the defense was based on hearsay and speculative connections. The defense suggested that certain symbols and arrangements of the victims' bodies indicated Odinistic rituals, but these claims were not backed by concrete proof. No known connection. The defense did not provide evidence of any known connection between Richard Allen and Odinist. Without establishing a link between the suspect and the alleged third-party perpetrators, the theory remained speculative. The potential to mislead the jury. Judge Gull ruled that allowing the Odinist theory could confuse the issues and mislead the jury. The speculative nature of the evidence could detract from the factual evidence and lead to unfair prejudice against the prosecution's case. In summary, the defense's Odinist theory was deemed speculative because it lacked direct admissible evidence and heavily relied on hearsay and conjecture. This led to the judge's decision to exclude the theory from the trial. In Indiana, for evidence to be admissible in court, it must meet certain criteria under the Indiana Rule of Evidence. The evidence must be relevant, meaning it has any tendency to make a fact more or less probable than it would be without the evidence. And the fact must be of consequence in determining the action. Evaluating the evidence. Sticks arranged like a rune. Relevance. The defense would need to show that the arrangement of sticks is directly related to the crime and not coincidental. Expert testimony. An expert in Odinist symbols might be required to testify that the arrangement is needed or is indeed a rune and not a random pattern. Blood on a tree in the shape of a rune. Relevance. The defense must demonstrate that the blood pattern is significant and not a natural occurrence. Forensic analysis. A forensic expert would need to confirm that the blood is human and possibly link it to the crime scene or the victim. Statement from an individual with the low IQ. Credibility. The statement, "What if I spit on the victim?" would need to be evaluated for its credibility and context. Competency. The individual's competency to make reliable statements would be assessed, considering their low IQ. Admissibility and appeal. Concrete evidence. The evidence presented must be concrete and not speculative. The defense would need to provide a clear link between the evidence and the crime. Judge's discretion. The judge has discretion to determine whether the evidence is admissible based on its relevance, reliability, and potential to mislead the jury. Basis for appeal. If the judge excludes the evidence, the defense could argue on appeal that the exclusion was a legal error. The appellate court would review whether the judge's decision was an abuse of discretion. In summary, while the evidence describes could potentially be admissible, it would need to be supported by expert testimony and forensic analysis to be considered concrete. If the judge excludes such evidence, it could form the basis for an appeal if the defense believes the exclusion was unjustified. All right. Let's see what everybody has been saying. Who are they going to blame it on next? Odinist wasn't good enough, so now it's a biker gang? The Circle has nothing but conspiracy theorists on the site. I guess the intentionally ignorant just want attention. When is sentencing? December 20th. At 9 a.m. Indiana is a death penalty state. Is it on the table? As of right now, no. And I'll tell you why I think it's not on the table. No, sorry about that. The reason I think it's not on the table is because Richard Allen is a 54-year-old man. It would cost a lot for the county of Carroll and state of Indiana to have the death penalty because there would be automatic appeals for that for years to come. Now, we figured out that the minimum is, let me see if I got this in here. I believe the minimum is 64 years and the maximum is 130 with what he's charged now. Does it really make sense to spend all that money on the death penalty when he more than likely will pass away in jail if he gets a 64-year sentence? Just the minimum. No, it doesn't. And I think that's why they haven't put the death penalty on the table. Lynette says, I'm pretty sure he'll get life without parole. Right. Which for him is a death sentence because of his age. Yeah, and it'll take years to get the appeal looked at. So I kind of been listening to others as far as how long. So if Richard Allen chooses to appeal this conviction, how long could it take for that appeal to be heard, gone through, a decision to be made? And I was told 3 to 5 years from now by many people. No sooner than 3, but more likely like 5. Holder has an alibi. Yep. Jen from the suburb says the right man was convicted. Dred says, thank you, Marv. Someone that knows what they're talking about. Well, I didn't for the longest time. Ask Andrea. This third-party defense stuff really confused me. And I was trying to figure it out, looking at sites, and I finally had to use Bing because I couldn't understand it. Even if Alan's defense team appeals to the Supreme Court, did I miss something there? Is there more to that? Historically and very fair coverage by Marv. Thank you. I'm trying my best. Yes, murder is 45 to 65 years. Indiana has life without parole. Yep, they brought in, that was his name, Eric Warren. That's why, for some reason, we can get a copy of that testimony, and we're certainly going to try, because the prosecution has asked for the transcript. Yes, there will be new attorneys for his appeal. Yes, and Eric Warren's is not accredited. It's not important to him either. And he did state that on the stand. Victoria says, Gull did her job. The OJ and Casey Anthony judges let in crap that shouldn't have been admissible. And we know it worked to confuse and distract the jury. Two perfect examples. Absolutely, Victoria. There'll automatically be different lawyers for Richard Allen's appeal. Baldwin and Rossi cannot take care of that. Oh, yes. You are right, SP74, because Luttrell did destroy that man on cross. He did a brilliant, brilliant job on cross and just destroyed him. Yeah, actually, that was Chris Darden's fault, but should never have happened. You're right. Jen says, this was my first and last true crime case. Nearly drove me crazy. Never again. Mentally, it was very difficult. I agree with you, Jen. Every case is difficult. And look at me, I'm over 45 years old, and I've taken many breaks on the true crime because you cannot just continually do it. The locals will stand on, but the platformers can't afford to. And in the middle of the night, everyone knows that RA shouldn't be free to walk the trails in town near them. Yeah, I agree. Let's see here. Yeah, the Kohlberger case, I think, is getting just as bad. Let's see here. So do you guys understand third-party defense now that I have laid it out to you and why it was not allowed? And it's really simple. You can't just submit speculative and hearsay evidence. You actually have to have concrete, admissible evidence. I am going to put a link in the chat. And this is for just for anybody who's interested like me and wants more information on this kind of stuff. I just put in a link to the Indiana Rules of Court, the Rules of Evidence. And that was some great things to read. As far as what is considered evidence, what isn't considered evidence, about offer of proof, because that was talked about in this case. Preventing the jury from hearing inadmissible evidence. And just all kinds of different things. I mean, I think that would interest some of you. So let's talk about the sketches real quick. In the Delphi murder trial, Judge Frangal ruled that the composite sketches would not be admitted as evidence. The primary reason was that the sketches were considered hearsay and could potentially mislead or prejudice the jury. So, there were hearsay concerns. The sketches were created based on witness description and a grainy photo. But the witnesses did not see the offender's face long enough to make a certain identification. This made the sketches hearsay, as they were out-of-court statements offered to prove the truth of the matter asserted. In the trial, all of the witnesses stated that the man they saw either at the Freedom Bridge or on the bridge or on the road were identified by the clothes that they saw the man wearing, and that they matched the clothes of the man on the bridge. So all this stuff about height, what color jacket, his face, not being able to identify his face, all of that was not taken into consideration, because they said that once they saw that picture of the man on the bridge, that clothes, the clothes that man was wearing, matched the clothes that they saw on the individual that they saw in the different areas. On the bridge, at Freedom Bridge, and on the road. Potential to mislead the jury. The prosecution argued that the sketches were not relevant to identifying Richard Allen as a suspect and could confuse or mislead the jury. The defense countered that the sketches were relevant because they did not resemble Allen. Well, of course the defense is going to want them in. Suggesting someone else might have committed the crime. Lack of in-court identification. The witnesses who participated in creating the sketches were not available for in-court identification of the defendant. This further supported the hearsay argument and the potential for unfair prejudice. Judge Gull agreed with the prosecution's argument and ruled that the sketches would not be admitted during the trial. The decision was made to prevent the jury from being misled and to ensure a fair trial for Richard Allen. The prosecution argued that the sketches could confuse or prejudice the jury for several reasons. Lack of resemblance to Richard Allen. Now, you got to remember that at the time that the prosecution did not want these sketches in, the judge had denied their request to enter 4 pictures into evidence. Those 4 pictures were what Richard Allen looked like back in 2017. And the reason the judge denied those pictures coming in is because it did not have a timestamp and a date on it. So, that would have really prejudiced the jury. Sketch quality. The sketches were created based on the witness description in grainy photos, which might not accurately depict the actual perpetrator. The prosecution likely argued that the inaccuracies in the sketches could mislead the jury into questioning the credibility of the overall investigation. Out-of-court statements. Since the sketches were based on statements from witnesses who might not have been present to testify, the prosecution argued that these out-of-court statements, hearsay, could not be cross-examined and therefore should not be used to influence the jury. Distracting from evidence. The prosecution likely believed that the sketches could distract the jury from more concrete evidence, such as physical evidence, forensic analysis, and direct witness testimony that directly linked Allen to the crime. Bias introduction. Introducing sketches that do not match Allen could introduce bias, making it harder for jurors to objectively evaluate the evidence presented against him. Focus on solid evidence. By excluding the sketches, the prosecution aimed to ensure that the jury focused on the most reliable and direct evidence of Allen's guilt, avoiding any potential confusion or misdirection that less reliable sketches might cause. In essence, the prosecution's argument was that the sketches, due to their potential inaccuracies and the hearsay nature of their creation, could mislead the jury and detract from the credible evidence directly impacting Richard Allen in the Delphi murders. So, initially, those are the rules. That's why it wasn't admitted. And was it the right decision by Gull? We'll find out. Because if Richard Allen decides to appeal, the appellate court will inform us. Let's see here. I agree, Miranda. Should have been, the audio at least should have been released. My hope is that after all the appeals are done and over, that the exhibits minus the crime scene photos and the audio will be released. Right now, I wouldn't hold your breath on either one. The only thing we can wait for is for either the prosecution or the defense to order transcripts. And as they're ordered, then we can get them for $1 per page. All right. Miranda, plus they never, okay. This channel Frank's behind the door, Tom Webster's Gravit Fig. I'm not sure. I think, did I miss something in that comment? Let me know. Let's see here. Please hit the thumbs up and subscribe and share. Hit the bell to be notified of any upcoming content. Yes, I do remember that. Everyone said I was making it up, and then look what happened. Explains why we couldn't find anything as well, because he hadn't been charged yet. Yes. And everybody makes a big deal out of Click's testimony. Well, in that hearing, July and August, he said he had no evidence that the Odinist did this. None. Yeah, I don't know what happened to all that money. It was more than 12,000, I can tell you that. Yeah, we were, Kibble. We definitely were. I don't know how many pages. I have to find out how many pages that testimony is. And then I'll be getting them. Oh, awesome. Thanks, Badass American. I appreciate it. If you haven't watched Hidden True Crime, she recently put out a members only video, and that is what I was going to talk to you guys about. I am in that. One of the things that I personally learned at the trial, is that the area that we thought Abby and Libby were found in was, in fact, not the area. So there was memorial walks and everything else that we showed people where we thought they were found. Turns out that wasn't it. I do have new footage of that area, And I will be showing it on a members only live. And I am going to wait and do that, start the members only lives after Thanksgiving. So we have, what's today? I think it's Sunday. Better check my phone. Yes, it's Sunday. So I've got a live set up for tonight, tomorrow night. I will have one Tuesday night and Wednesday night. And then Thursday is Thanksgiving. I want you all to enjoy your time with your families and friends. Friday, I will be going out of town. We are going up to my daughter's for the weekend so that we can spend time with her for Thanksgiving. And then we'll be back, and I believe on Monday. So I will start my lives back up Monday again. And on Wednesday, that Wednesday, we will have a members only live. And while I'm thinking of that, one second here, I gotta make sure this is on. All right. Hopefully that worked. I just gave out 5 memberships. Let's see who got them. Gibbo was gifted a membership. Audrette K was gifted. Judy Holiday, Melissa Rinner, and Unsilent Bob 420. Congratulations. So glad that you were able to get a membership. You're welcome. So I gifted 5 tonight. Tomorrow or Tuesday, I will gift out the last 5. I get 10 a month that I'm able to gift out to you guys. So I did 5 tonight, and I'll do 5 another night. How come you say that, Bonnie? I'm curious. Because she says if this trial was done in New York City, totally different outcome. What's different about New York than Indiana? I'm curious. I'm just curious. I know different states have different laws, so absolutely things can be different from one state to the other. Miranda Lee, thank you so much for becoming a member. She's been a member for 2 months. All right. You're welcome, Miss Laura. Hope you have a good night, and we'll hopefully see you tomorrow. The jurors paid a lot of attention to what was going on, and I can assure you that they paid attention to the defense, and the defense burned that jury more than once, just like they have to us for the past few years. Things like oh, a hair was found in Abby's hand, and it was not Richard Allen's. And then come back the next day at the actual trial in opening statements and say, oh yeah, the hair was determined to be a female hair, and it was probably from a member of Libby's family. Things like that happen more than once. And the jury caught on to it. Yes, Lollipop, I'm so happy to be home. You're right. The defense could have put on better evidence. And it didn't have to be Odinist evidence either. The defense team could have actually learned how to properly phrase a question without getting an objection for leading by the prosecutor over and over and over and over again. The defense should have known how to properly rebut somebody's testimony, but however, they didn't, and so the prosecution objected, and it was sustained. The defense could have put on this evidence they said they had, but they didn't. They had all the opportunities in the world. They didn't do it. In my opinion, Richard Allen would have been better off with Labrato and Scrumman. I sat there waiting and waiting and waiting for the defense to bring it. Never happened. Never happened. I agree with you, Victoria. All right, everybody. Well, that's all for tonight. Come back tomorrow. Like I said, we're going to go through those Frank's motions, and we're going to learn on whether their information was admissible evidence or speculation. We're going to end up talking about that in one of these series once we talk about evidence. Thank you, everyone, for joining me. Once again, congratulations to the 5 individuals that got the free memberships. I will be giving out 5 more in the next day or so. Hit that like button. Leave me a comment below. Doesn't matter what your opinion is. If I don't agree with your opinion, I'll let you know, or I might not. Just remember, everybody, make sure that you're watching and listening to people who actually care about this case. These people, these individuals, like I said, there are individuals out there that are still bashing the families, still pointing out that they are the ones that committed these murders, and there has been a man. His name is Richard Allen, and he has been convicted and found guilty on all 4 charges. So, with that being said, Have a great night, and I'll see you tomorrow. Bye. Thank you for watching Beyond the Evidence. Today, I gave you my own opinions and analysis, but I always encourage you to do your own research and form your own conclusions. If you're interested in true crime and want to join me on this journey of discovery, make sure to subscribe and hit the bell icon so you don't miss any of my uploads. If you'd like to support the channel, join our membership, and if you have any suggestions for cases that you want me to cover, feel free to leave them in the comments below. Thank you for watching, and remember, justice matters. This is Beyond the Evidence, and I'll see you in the next video.